Thanks for seeing me at such short notice. We're buying a property for our operations team, and the estate agent has sent over an offer to purchase. We've got a few days to sign, so I just wanted to make sure that the offer to purchase is just a starting point. We can still negotiate later.
That's a very common assumption, but it's actually not the case. An offer to purchase, often just called an OTP, is far more than a letter of intent. Once both parties sign, it becomes a legally binding sale agreement. So it is absolutely critical that you understand what you are committing to.
Really? I thought that only came later with the formal contract.
No, the OTP is the formal contract. There usually isn't a follow up agreement unless something very specific has been agreed to upfront. In fact, the signed OTP is what is used in a transfer of property. So if there's something missing or unclear, it could create problems.
Okay, that's concerning. What kind of issues are we talking about?
A few come up repeatedly. First is the matter of suspensive conditions. There are clauses that delay the agreement coming into full effect until something happens, like the buyer securing a loan. If the condition isn't clearly written or not met in time, the entire deal can fall through.
We will be applying for finance, so that clause definitely matters.
Exactly. The wording must be clear about how long you have, what happens if the bond is not approved, and whether the seller has the right to walk away. If any one of that's vague, it creates room for dispute.
What about things like fixtures or the date we move in?
Also important, if the OTP doesn't spell out what's included, like the air conditioning units, built in shelving, or generator systems, then you can't assume anything. The same goes for occupation date, occupation rent, and who handles the rates and taxes. If it's not written into the OTP, it's not enforceable.
Okay, but let's say something changes later. Can we just verbally agree and carry on?
Not advisable in law. If it's not a signed agreement, it doesn't count. Verbal amendments are very difficult to prove and almost always end in disagreement. If something changes, you need a written addendum signed by both parties.
This is sounding less like a formality and more like a risk if we don't take it seriously.
Exactly. The OTP is not the place for vague language or we'll sort it out later thinking. It's a binding contract that commits you legally, and getting it wrong can mean financial loss, project delays, or even court proceedings.
So, what's the best course of action?
Here are five critical steps I can recommend for any business. Never sign an OTP without reviewing it with your legal team. Make sure all suspensive conditions, responsibilities, and timeframes are clearly worded. Confirm all financial and occupancy arrangements are specified. Be wary of templates and agent drafted clauses as they're not tailored to your transaction. And finally, educate your internal teams, especially finance and property divisions, so they know not to sign anything that has legal weight without oversight.
This is really helpful. I can see how even small oversights can snowball into serious problems.
They can, and it happens more often than you think. A little diligence now protects your investment, timeline, and peace of mind down the road.
I'll get the team to send you the OTP today. I'd rather know now if something's missing than deal with a dispute later.
That's exactly the right approach. We'll take a close look and make sure all your interests are fully protected before anything is signed.